I'll tell you this right now. California's three strikes law does not work, has not worked, will never work. Been an attorney since 2010, and I've never seen it deter someone the way it was supposed to, the way it was intended, or even punish someone appropriately. In this video, I'm gonna break down what exactly the California three strikes law is, where it came from, what's changed over the years, and where it could potentially be going. We'll also be debunking some misbeliefs or inappropriate thoughts about it, or things that are just not true, to help you understand what you need to know about California three strikes law to protect your freedom, to protect your future, know your rights. What we're gonna do now is we're gonna talk about the fundamentals of California's three strikes law. And before we do that though, it is essential to understand and define what is a strike in California. A lot of people think that any felony is a strike, any crime is a strike. Not true. What a felony strike is in California is what California defines as a serious or a violent felony. So if you're charged with what California lists out as a serious felony or is what California defined and lists out as a violent felony, that is a strike felony. And that is something, if you're convicted of it, will stay with you for the rest of your life for any future offense you may be accused of committing. Now, what is the real purpose of the California three strikes law? Well, the purpose is to punish someone more who may have suffered a prior strike or may be charged with a current strike, or in some instances, when it's really bad, both. To punish that individual more than they would someone who may be their first criminal offense, without a bad prior criminal history, without having been convicted of a serious or a violent felony prior. Now, California courts are presumed, if you have a strike prior, to double the sentence on your new felony case if you're convicted. And that's not even if this new felony case is a strike in and of itself. So you could have a situation where you're charged with a serious or a violent felony in the past, you're convicted of it, 20 years, 15 years, whatever the case may be, you're charged with a new felony, and the courts are presumed to double up that punishment to make it a mandatory state prison case, which means you can't get probation, you can't get county jail, you have to go to prison, and the presumption is that you will go to prison for at least twice the term of the original offense. Not always the case, there's ways to strike the strike, but that's the underlying premise of California's three strikes law. Three strikes law. How do people wind up spending the rest of their life in prison? 25 to life. For the longest time, even before I moved to California in 2006, you hear about the three strikes law and it's like, oh my God, are people really like taking a piece of formula or a piece of bread at the store and spending 25 to life in prison? What kind of Wild West is it out there? Well, that's not really the case. In fact, it was though when the case first started, right? When three strikes first started in California, there were situations if you had two or more prior strikes, committed a new felony, even if that felony was not a strike, you would hear horror stories of people spending the rest of their lives, arguably, in prison, not knowing if they're ever going to be paroled. Well, thankfully, the laws changed over time, and now you're required to be convicted of a third strike in and of itself with at least two or more priors before you will fall victim to the 25 to life situation. So if you have two strike felony priors and your new offense is a felony, but is not a strike felony, you are out of the realm of three strikes law. Now, your sentence can and likely will still be doubled under the three strikes theory, but you're not subjected to 25 to life in prison the way you could have been years ago. That was a step in the right direction, and what we've seen over the years is a softening on what a lot of judges viewed was their hands being tied when someone has a strike prior. Well, I can't do nothing about it. They've got to go to prison. We've got to double the sentence. Not necessarily. There are ways to strike priors. It's called a Romero Motion, which is something that the defendant, through his or her attorney, will file with the court and outlines the factors and says how this case is not really what the intention of the three strikes law was meant to prevent, was meant to deter, and was meant to punish. So it's important to understand how the three strikes law has evolved over time to get a good understanding whether you or a loved one falls subject to it if you're facing a felony charge, let alone a serious or a violent felony charge as defined by California law. We've talked a lot so far about what a strike is, what a second strike is, what a third strike is, and how that could land you in prison for the rest of your life. As California law currently stands, the third strike needs to in fact be a strike. It is not a situation anymore where you could have two prior felony strike convictions, have a third felony, and wind up in prison. Your third strike actually has to be a serious or a violent felony in order to be subjected to the potential for a 25 to life sentence. Now, I say potential because the judge's hands, despite what he or she may think or what their beliefs may be, are not in fact tied. They almost always, if not always, have the opportunity to strike the strike. The defendant, through his or her attorney, can file something known as a Romero Romero Motion, which outlines this case, the current case, the prior strikes, and basically will argue to the judge that this case falls outside the purpose of the three strikes law and should not be considered subject to a 25 to life sentence. The judge then, in his or her discretion, could quote unquote strike the prior strike. Doesn't mean it goes away for all purposes. It just takes the defendant out of that 25 to life realm, and then much more sentencing options are on the table. So where did the three strikes law come from and when? Well, like many things, it came from fear, it came from outrage, and it came from sorrow. In the mid-1990s, California saw a large number of high-profile, highly publicized cases, a lot involving children, where children were harmed, and they were harmed by people who had suffered prior strike. So the public was outraged. How are these people allowed to be on the street if we've already been given the sign that they're incapable of living in society? Or at least that was what the argument was. So California legislature does what it does in times like this. It took an opportunity and turned it into bad law. And the California three strikes law was founded, came to fruition in the mid-1990s. Well, over time, right, the purpose of it is to deter criminal conduct, is to punish. Arguably, maybe some people say it could be rehabilitate. The reality of the situation is it did none of that. All it did was keep people in jail, in prison, for a significant amount of time. Prisons that were incapable of rehabilitating them. Prisons that were incapable of treating them for the issues that they had. And it did nothing really to protect the California public. So over time, what we've seen is a softening on the three strikes law. Year after year after year, it's less and less likely that if you have a strike prior, let alone 2 or 3, that you are going to fall victim to it over and over and over again. That you're not going to fall into this trap of significant double-digit 30-year, 40-year sentences just because of your strike priors. We have evolved as a state. Mostly that's been for a good thing as it relates to criminal justice. And we anticipate in years to come, as an attorney here in California since 2007, we're going to see a lot of changes in the three strikes law and a lot of changes understanding what works, what doesn't, and what has a realistic chance of working in the future. All right, so we've covered the basics. Now let's talk about the evolution of three strikes law in California. We know it started in the mid-1990s. A real big important time for three strikes law was in 2012 when the law changed, requiring that the third case, the third felony, if you are in fact going to be sentenced to an indeterminate prison sentence, third strike actually has to be a strike. Because for the longest time, since 1994 or so, your third strike didn't even need to be a strike. It could be a wobbler felony. It could be something that could be charged as a misdemeanor or a felony. It could be a non-violent offense. It could be a non-serious offense. And you wind up hearing stories of people spending the rest of their lives in prison. Well, that all changed in 2012. Now it requires you to actually be convicted of a third strike in order to fall victim to a third strike offense. So there's been a lot of movement in the right direction that has helped and has also coincided with a lot of prison reform in California. There's been a lot of change going way back to 94 to 2012 to the present day. We anticipate it's going to continue. Most of it will be for the good. Now, at this point in the video, we've talked about how California's three strikes laws have changed, how it's evolved, and how no matter what, the judge has discretion to strike a strike for purposes of your new case. And we talked about something known as a Romero motion and Romero factors. Well, let's talk about them a little more and let's understand them by let's defining them. So say you're in a situation where you have a strike prior conviction and your new felony offense may or may not be a new strike, but you were convicted of that felony offense. And because of your strike prior that you either admitted as part of a plea deal or that a judge or jury ultimately found true. And now you're in a situation where you know, unless the judge strikes that prior strike, you know you are going to state prison and you know that you're going to get at least the low term doubled because of that strike prior. And the biggest thing I could tell you, having practiced criminal defense, particularly in San Diego, is the age difference or the gap in time between the first strike and the second strike or the first strike and this new felony. If it's a situation where you're talking 2, 3, 4 years ago and now you're out committing a new strike alleged, that's going to be a problem. How long have you been out actually matters too. Because imagine you do 15 years on a case and your defense attorney's in there, judge, he hasn't had a strike in 15 years. Well, anybody who's awake is going to say, well, because he's been in prison for 15 years. So the time difference may be large on a calendar, but not an actuality of time that you're out in society. What's your work history? What's your school history? What's your family history? And also, let's not get away from the difference or disparity between the original offense and what you're charged with now. So if your original strike offense is far more serious than what you're charged with or what you're convicted of now, a judge is likely going to be more inclined to consider, if not outright grant, that Romero Motion, because he or she does not want to send you to prison for a double-digit prison term or doubling up your low term that you could get, if not more, when the new offense is less serious. You're actually moving in the right direction. But if it's the other case, then you have a DA arguing about increasing criminal conduct. That's where you're going to run into problems. But with the right attorney at the right time, most things are possible, one of which being getting a judge, if not a prosecutor, to agree to strike your prior strike. That makes you probation eligible. That takes state prison off the table as being mandatory and gives you an opportunity to regain some control over your future and your freedom when you're charged with a strike offense in California under the three strikes law. We've covered a lot in this video, going back to the mid-1990s when three strikes law came into effect in California, through the big change in 2012 requiring the third felony actually be a strike in order to fall victim to this 25 to life law. What we've learned and what we've seen over time is a softening of the position. Why? Because it doesn't work. Sending someone to prison for a significant period of time without a plan to rehabilitate doesn't work. It causes prison overcrowding and does not make California or the world a safer place. We anticipate in years to come a lot more changes, particularly as it relates to three strikes law in California. But it's important to get the word out there about what applies and what doesn't. There's still a lot of misconceptions in California, particularly as it relates to the three strikes law. A lot of people don't know about the change in 2012, about requiring that the third felony must be a strike felony. A lot of people don't know about the judge's ability to strike a prior strike and what that means and what it doesn't mean for this case and any future cases. And a lot of people don't know about the Romero motion and the Romero factors that a defendant, more importantly their attorney, could file on their behalf on what to consider. So while we always encourage you to like and comment on these videos, say what you want to say, ask any questions you want to ask, the best thing you could do and what we're asking you to do is share this video to someone that you may know or may have a loved one that's going through it. Someone that may be sitting in prison right now. Send it to their loved one about the three strikes law in California so they know about the changes. They may be eligible for certain relief. Send it to someone going through this right now who's up against the system, who feels like all hope is lost, so they know there's an outlet out there to protect their freedom, to protect their future. It's knowing their rights.